I'll call the first case, case number 116761, State of Kansas v. Corey Leroy Yazell.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Corey Yazell, and I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, this is a case out of Johnson County where Mr. Yazell was convicted of an offense and placed on probation by the Johnson County District Court. Eventually, he was alleged to have committed violations of his terms of probation, specifically that he had done certain things, and the evidence in support of that revocation assertion was some police reports or reports from a person in Missouri. At the end of the revocation hearing, the district court found Mr. Yazell was in violation of his terms of probation, and he was remanded to serve his sentence. As is his statutory right, Mr. Yazell chose to appeal that finding, that revocation finding, violation finding, and that was appealed to the Court of Appeals. We briefed that issue about whether, for example, hearsay can be used, unsubstantiated hearsay can be used for purposes of violation finding. My colleague filed a brief saying why that's possible or why Mr. Yazell waived his right to due process in this case. And that case was before the Court of Appeals, and the Court of Appeals then, based on our docketing statement, I suppose, said it appears that maybe Mr. Yazell has completed this sentence, and is this appeal therefore moot? And we each responded to that for different reasons, and ultimately the Court of Appeals dismissed this case as moot.
I feel compelled to ask the first question just because I'm sitting here in Justice Johnson's old chair. We accept the good faith statements of counsel all from the podium and in the course of proceedings all the time. Why can't you just tell us where your client is so that we know that this mootness issue is real or not, and then get on with the merits of the case? And I ask that because as I look at the record, you filed this petition for review in January of 2018, and now 21 months later, and I suppose some of that may fall on us for criticism, but it seems like this thing is a good example of why we are clogged up in the appellate system, that we just can't get to the merits because we're sort of creating alternate universes of what's been proven and not. So let's just start with, why can't we get from you where your client is he in jail or not? You surely know, and accept that good faith statement of yours, which we do all the time, and then get on with the merits of the case.
So I think I have a two-part answer to your question. One is because I don't think it's my job to be a witness against my client ever as an attorney. If you want me to be a witness, then I need to be in a different role. I'm his attorney.
How is that being a witness against your client?
You've asked me to state facts that are relevant to whether my client gets a day in court or not.
Well, you're going to get your day in court or not depending upon whether the case is actually moot. You're sort of hiding the ball that keeps us from knowing whether we can analyze the mootness question or not. So that's why I'm getting back to the notion of this really just seems like you're hindering the process, not speaking against your client, you're hindering the process because we can't get to the merits until we know where this guy is.
So remaining on that first point then, which is, I believe that if I come in and say, in any case, I'm not saying in this case, but in any particular case, if I come in and say, my client is no longer in jail, and that results in his case being found moot and him not getting a day in court, in my opinion, I believe I'm being a witness against my client. And ethically, that it's not my job to do that. If there is somebody that thinks this case is moot, it's the state. And if the state wants to have my appeal dismissed and feels that they have factual grounds for that, then they have the opportunity to prove it. Our argument in this case is simply that the state didn't prove it. And it is my argument that it is not my obligation to prove that on behalf of my client. The second part of it, Justice Biles, I just want to be really clear. It is not the case that surely I know anything. I don't have investigators. It is often the case that we have difficulty having contact with our clients in different contexts. Even if a client, for example, isn't in prison, that doesn't mean they're not in custody or that they have some other sort of restraint on them. And I may or may not know about that. And I, in fact, do not have the resources to always find that out to the certainty that I would need to be able to come in and tell this court whether my client is in custody or not.
Should there be a mechanism where we can determine that? I'm assuming that your position is custodial status doesn't matter in this case. That's your number one position. But if it did, or we have a situation where it does, should there be a mechanism for us to determine that in an accurate way? And in your mind, what would that be?
Certainly with regard to whether my client is under the custody of the Kansas Department of Corrections at a particular time, there may be some mechanism, for example, and again, we haven't fleshed this out, but there may be such a thing as like a certificate of discharge that the Department of Corrections gives to a person. Some sort of certificate that certifies, by somebody that has authority to make that certification, that this person is no longer in the custody of the Kansas Department of Corrections.
Would that be something that we could undertake, or would that be something that you or either the state or you as an advocate would have to undertake? I'm just wondering about what your thinking is in regards to what action we can take to discover, let's say, custodial status.
Sure. So, I think, for example, when the Court of Appeals issues the show cause order in this case and says, it looks like, based on the docketing statement, this person may no longer be in custody. And I understand my colleague's argument that, based on the length of the sentence and how long it's been, it may be very likely that a person's no longer in custody. But then that's different than we know he's not in custody. Maybe he's in custody for other things. We don't know. So possibly one thing would be that the state, in response to that, could try to seek more competent evidence like that certificate. And I don't know. This court can give us some guidance on what it takes. I think about, and I'm cautious. I'm trying to try it cautiously here because I know that, for example, my office answers orders to show cause, lots of orders to show cause about things like late notices of appeal. And we put on certain kinds of evidence. Usually we try to get affidavits or things like that from lawyers or people. But what the state did here is simply put on a website that itself disclaims its accuracy and then says we also talked to somebody at the Department of Corrections who they do not have any authority to warrant anything on behalf of the Department of Corrections, and says that's sufficient evidence. If this court thinks that that's sufficient, whatever it is, I'm having a hard time answering your question because I don't know exactly what would be good enough.
Right.
But what I'm arguing is this should not be good enough, whatever it is. If the state brought in a certified copy of a certificate of discharge from the Department of Corrections saying we warrant under law this person is no longer in custody, that feels like a much stronger case than a website that it disclaims its accuracy.
If the legal question were standing as opposed to mootness, would that shift the burden of proof onto your client to demonstrate that he has standing to challenge the revocation?
We haven't briefed that, so I'm just answering your question as best I can. I believe the rulings of this court are that a party doing an appeal, seeking an appeal, has the burden to show their own standing.
I think that's right.
Yeah.
And standing is a jurisdictional question, whereas mootness may or may not be. Would you agree with that?
I would agree that you have held that standing is a jurisdictional question. I believe the rulings of this court are that mootness is clearly not a jurisdictional question. It's a prudential question.
And if we have a independent duty to, apart from the arguments of the parties, raise our own subject matter jurisdiction on our own, then isn't it a fair question to ask you to demonstrate why your client has standing? And isn't that a way to get at his custodial status? Because now you're not being a witness, you're making an argument on behalf of your client. Like, how does he have standing, I guess, is a question.
My client has standing. He's the agreed party in this case. There's no doubt my client has standing as that concept is understood at law. My client is the aggrieved party in this case. He's not trying to raise a claim on behalf of somebody else. He has standing.
What's the particular harm that he stands to suffer?
Okay, so, and that kind of moves to the second sort of sub-issue here. Even if I assume for a second that, or assume for argument's sake that you find the state's proof in this case adequate, that my client no longer is in custody of the Department of Corrections, there still are consequences from a judicial finding that my client violated the terms of his probation. And so
You'd have a stronger argument for a particularized harm if your client was still in custody, right?
Oh, sure.
And
sure.
are you not making that argument?
I'm not making the argument. I'm saying that I can't present information to this court about that status.
Okay, so you're relying instead on the ancillary impacts, even post-custody, that might flow from the judicial determination.
I'm not conceding that my client's not in custody. And you're right that that's the strongest, that's the most direct, that is the direct consequence that we would all probably agree, even my colleague would probably agree that my client should be able to appeal that situation. But I am arguing in the alternative that even if you would say he is completely done and with this sentence, that a judicial finding that a client has violated the terms of probation still does have sufficiently direct consequences that it's not moot just because he's finished that term.
Your
Is
client.
there any-
No, go ahead.
Is there any factual way your client could still be in custody?
Sure, he could have committed another offense.
Right, but
He
on
could be
this
in jail in
crime-
another state.
But on this crime, and can't we only impact this crime, this sentence that's at issue here? And is there any way, just by looking at the sentence and knowing the elapse of time, that he could still be in custody on this crime?
On this crime, again, it's really, you're asking me, it's very speculative. The question you're asking is very speculative, I think.
What could have continued?
If you give me some time and could I figure out a way that he could still be in custody? I'm willing to admit that I understand why the Court of Appeals issued the order to show cause based on our docketing statement in this case, and the power of your argument regarding the logic of the situation. But that's not the same as proof. That's our point.
But do we have to prove something if we can look at a calendar and count the number of days and know that they've expired? Even if he served the longest possible, no jail time credit, no anything, or good time credit.
Okay, you're asking me to speculate. So, let's say, for example, he was taken he was taken to another state to stand trial somewhere there. He could still be there for all I know, and have not completed the term in Kansas. That he still has some period of time to serve left. I'm not saying that's the case, Your Honor, but you asked me, is there any way? And so maybe that's a way. That's just one I can think of standing here.
You complain that what the state offered to show that he was not in custody was hearsay, unreliable. But how far does your client signing an express waiver to hearsay once he's placed on probation, how far does that go? Does it go to this kind of hearsay? And why doesn't it? I realize it's an appellate process, but he did sign a waiver that hearsay, and that happens all the time in probation revocation hearings. This is a probation type of case.
Sure. My time's out. Can I complete the
course.
answer? So, Your Honor, I hadn't thought about that because my colleague hasn't raised that, and I think maybe the reason my colleague hasn't raised that, he'll speak for himself, of course, is that the waiver provision that was talked about in the briefs on the merits really had to do with the revocation proceeding. It had to do with admission of potential out-of-state statements at the revocation proceeding, and by its terms, I'm not aware of it going past that at all.
One of the exceptions you argued for mootness was that this was capable of repetition. And I frankly don't understand that argument, so I want to give you the chance to explain to me how this can be capable of repetition when you're arguing the facts of this case don't amount to a violation of probation. You're just, Is your issue on that point solely related to the hearsay?
Yes. It's that the district court in this case, over our objection, said I'm gonna consider these police reports or affidavit or whatever from this out-of-state witness, and my client was not able to cross-examine them at the probation violation hearing on whether or not my client violated the conditions of probation.
Then we wouldn't peel the onion one more layer to get to the question of whether there was a probation violation if we held that way. That's your point. So we'd have to remand for more proceedings.
New probation revocation hearing is what you're asking for, in essence.
That if this court said you're right, you shouldn't consider that. Now, I mean, the exception that we're talking about assumes that a case is moot, right? Legally moot. But says you can still go forward. And I'd have to, I guess, kind of look at the disposition in a case like that where you found it's moot, but you're reaching a legal issue because it's capable of repetition.
Could it impact him?
Mainly based on the second one, yes, because I mean, it's not just in this case, it's not just a case of reversing the sentence or the imposed sentence, it's also reversing the judicial finding that my client committed a probation violation. And you have the power to do that. He is statutorily entitled to appeal all of the adverse findings. One of the adverse findings in this case is that my client violated the conditions of probation, and that's what he wants his day in court on. Thank you, Your Honor.
So we never get to the
Go ahead.
we never get to the theoretical question of whether this fits the exception of capable of repetition. You're saying you don't need to because this is still a direct appeal of that issue.
I'm arguing the alternative. I'm arguing that the state hasn't proven it's moot.
Yeah.
that the state hasn't proven that he's not in custody. That even if the state and this court conclude that he's no longer in custody on this, it's not moot because I bet district judges sitting here in this room have at times looked and said, I'm not giving you probation because you failed probation before. And then even if you find it's moot, legally moot, there's an exception that says this court should answer, or the Court of Appeals should answer the question of, is unsubstantiated hearsay usable for this kind of proof?
And just real quick, the remedy you seek on basically your primary question here is the state didn't prove he isn't in custody is what? We would remand this to the district court for a hearing to determine if he's in custody or not. What would we do?
So I mean, what we're asking for is that the Court of Appeals was wrong to dismiss this as moot.
Okay.
So I'm asking this court to remand this to the Court of Appeals to decide this case on the merits of the briefs that we filed 2 years ago. Now, what I'm saying is, if you think, on this question of what the quality of the proof was about whether he's in custody, if you think that there's a sufficient issue there, then follow Rayburn and say this is how we resolve. Appellate courts don't decide facts. If there's a factual dispute and the state or the Court of Appeals wants resolution of that factual dispute and have witnesses, for example, then remand it and have witnesses.
What if we were determined that some of the allegations that he did not refute? In other words, there's no point in sending this back for a hearing. The reason I ask that is there's some indication in the record, I think, that the district court relied on your client's failure to notify his probation officer of changes of employment, his residence, and his telephone number.
I'll have to look at that closer, but even if it was, the district courts clearly relied on the information from the out-of-state as part of the decision. A district court can look and say, I think you violated something, but not find a person in violation. I think that's within the power of a district court. And so the cumulative effect of these things would still be something that would be taken into consideration.
Very well. Any further questions?
Thank you,
Your
Your Honor.
counsel.
Mr. Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas in this case. This court should recognize that the Court of Appeals justifiably dismissed this case as moot when it recognized Mr. Yazzel was no longer in custody.
How did it recognize that Mr. Yazzel was no longer in custody? How did they make it's not very clear at all how they made that determination.
My understanding, they made the determination first by looking at the record that had been submitted to them from the trial court when they issued the show cause order. As Mr. Hodgkinson mentioned, the state, we did file our merits brief at the Court of Appeals, and the clock was still ticking when the Court of Appeals apparently recognized from the journal entries that had been submitted as part of the underlying record that Math told them his sentence should have run out. He had been remanded in October to serve the remainder of a 14-month sentence. He had already served something like 4 to 5 months of that sentence. That was October of 2016. Then by the next December, 14 months later, after he had been remanded on a 14-month sentence for which he already had 5 months credit, then they issued the show cause order asking the parties to inform the court as to why the case should not be dismissed as moot. That was the point at which the state submitted to the Court of Appeals a short response to the show cause order that included a printout from the Kansas offender lookup system for status through the Department of Corrections. That printout laid forth the case that Mr. Yazel had been remanded to serve DOC time on. It recited his location history and so on.
The printout says you should not derive any accuracy from the printout.
There's a disclaimer on that printout that I'm sure some attorney at the Department of Corrections required.
Well, it doesn't
on
matter.
that website.
It's there.
It is there.
It says you don't rely solely on this document for its accuracy.
And so the state then contacted Cheryl Hensley in the sentence computation unit and sought confirmation of what was on the printout through a phone call to her at the Department of Corrections here in Topeka.
But she just counts, right? She doesn't go look in the cell and see if he's there, right?
I don't know what she does.
So she's doing the same thing effectively.
We don't
I
have
don't
any
know.
proof that she does anything more than what the Court of Appeals had done itself before it issued its order to show cause.
We don't.
Well, what about an affidavit from somebody with the Department of Corrections? Did you think about that to satisfy Supreme Court Rule 2.042?
I did not think about that, and the reason why I didn't think about it is because, number one, when a defendant or when an appellant files his docketing statement with the clerk of the appellate court, there's a line on there that requires them to inform the court of the custodial status and their soonest possible release date. And the appellant in this case did that. He provided a date that long since predates when the show cause order was issued. And my understanding is that docketing statement did not incorporate any sort of affidavit or any sort of attestation to when his sentence would run out. And Rule 2.042 does not require such an affidavit either. It requires the state to inform the court of changes to custodial status, and the state did that here.
And you believe that met the burden under the rule for the state to simply send in a copy of the website and an unsworn statement that you made contact with somebody with the Department of Corrections and they verified they'd been released?
As an officer of the court, I feel as though that was sufficient to comply with Rule 2.042, correct?
Okay, all right, thanks.
The Court of Appeals found it sufficient to decide their show cause order on that basis. If an affidavit or if, as Mr. Hodgkinson posits, an adversarial hearing is required to demonstrate the defendant's or the appellant's custodial status, then I suppose we need to be remanding people from DOC before they can docket their appeal as well, so we can confirm their status.
But
There's nothing.
That's merely a notice. It would perhaps be the thing that would spark a show cause order, but that's all it does, isn't it? And that sparks then an adversarial proceeding where both sides then get an opportunity to present either arguments or whatever evidence is necessary if it is disputed. I don't know.
If it is disputed, I think that would be the case. But here, carefully, Mr. Hodgkinson has never disputed the veracity of the information the state put forth.
And perhaps disputed was a poor choice of words by me. Rather than, maybe it's more like concession. If, anything short of a concession then would trigger the typical back and forth that we would require to test the truth of a matter.
That's true. If it were disputed in some way, I suppose that would be the case, that some sort of adversarial hearing, or perhaps if he wanted to somehow dispute the information the state put forward, rather than simply saying the information was unreliable, but to dispute it somehow.
I'm sorry, I didn't mean to step on you. Why can't he just put the state to its proof? Just say, state, you have to do more here. I'm not going to just roll over and concede.
If we run that out to its conclusion as to what that would look like in a case such as this, when the state is arguing that the defendant is out of custody, he's run out his post-release time, he's released, then presumably what we would be doing is issuing an order for the defendant to appear in district court. He would be receiving a notice on a case that he knows he has served all of his time on. We'd be trying to find him and sending out a note. Presumably we'd do that through an order to appear rather than an arrest warrant. But even if we sent him an order to appear, he would know that he's been released from DOC on this case. He's served every day of his sentence.
Why
So if-
would we have to go to those extremes when we have rules that allow for governmental agencies to produce business records as under hearsay exceptions? Aren't there ways to get around having to do an in-person hearing?
I don't know if there are. Mr. Hodgkinson has argued for an in-person hearing. He has sought a remand to the district court for an opportunity for his client to be present at a hearing whereby the state would be required to prove the custodial status of Mr. Yazel.
He has said in this case, but I think he also was talking about a potential certificate of completion that would be presented to somebody upon discharge, and the state could then use that.
If that's what this court would like the state to do, we can absolutely do that. We feel as though what we had already supplied through the Court of Appeals show cause order had satisfied that order. That's what the state has done in the past. That's what has always satisfied the show cause orders before. But if this court is in a position to revise or amend, update that procedure whereby the state can respond to those show cause orders, we're happy to do it in any manner that this court directs us to do so. We felt as though we were already fulfilling.
Do you have any ideas along that line? What would be maybe something that doesn't have an express disclaimer on it? What? And I know I'm putting you on the spot here a little bit, but what in your mind would satisfy a little higher standard here, a higher standard?
I suppose presumably some sort of affidavit from the Department of Corrections, if they're willing to supply those to us.
When you said that you did what had satisfied the court before, you're referencing the Court of Appeals, right?
Correct, in such show cause orders.
Yeah.
Correct.
Is all this evidentiary difficulty that we're having here a result of analyzing the issue through the wrong legal framework? In other words, is mootness really the right legal framework to analyze this question?
For this question, I believe it is, in that it is moot because Mr. Yazel no longer...
Well, I understand all the parties make the argument. And of course, the Court of Appeals started this with their show cause order to show why it wasn't moot.
We had briefed it on the merits.
So I understand this question is a new question in the case, but I guess I'd just like the state's response to the suggestion that perhaps standing is a more appropriate legal framework to analyze this question.
I believe both would be appropriate. Standing would be appropriate in regard to a defendant who is no longer in custody and has nothing to lose or gain by this appeal. But I believe as though mootness is relevant to the extent that historically the mootness doctrine has examined cases in which a party no longer has an interest in the outcome of the litigation sufficient to ensure that that party is zealously advocating the position that they purport to be arguing or supporting. And here Mr. Yazel doesn't have the same motivation or the same interest as somebody that was in or would be in DOC custody.
Well, he seems like he's pretty zealously advocating his position. So if that's the purpose of the mootness doctrine, it seems to have been satisfied here.
It's one purpose, but I don't know that he is necessarily all the way through here, and if it were remanded to the Court of Appeals and then further remanded to the district court, I don't know that the advocacy would be the same and the arguments would be the same as what that would be put forth from counsel representing somebody who is in custody on the case for the duration. And this defendant is not that one. And that's the reason why the uncontested information that the state put forward to the Court of Appeals in responding to the show cause order should not be ignored. It doesn't need to be ignored by this court. This case should be found as moot. It should be properly considered moot by the Court of Appeals.
My problem with that, and let me push back, because my problem with this whole thing is that we're here on one of my problems with this is we're here on a petition for review of a Court of Appeals order. I've got the order in front of me. It's one sentence long. and it says, we looked at the response to show cause, and the case is dismissed as moot. And I have no idea, sitting here, what the basis was for the Court of Appeals decision that I'm being asked now to review. And it seems to me that what has to happen here is to send this thing back to the Court of Appeals and say, tell us the basis for why you think this case is moot. Because you're making a lot of arguments about why it's moot, but I don't know that those are the same arguments the Court of Appeals fought. And I don't think it's fair to ask us to shadow box with all the permeations that are going on here. This is just an order that doesn't tell us why they're doing what they're doing, which is the challenge. If we can't figure that out, then we've spent 21 months really just to send it back and say, could you give us a little more detail so that these guys can come back up in 21 months and argue it. This is the alternate universe that I think we're in right now, and it's frustrating. But the reality is, we're here on petition for review, and we can't figure out the basis for the Court of Appeals argument without furnishing it for them and then either shooting it down or accepting it. What's your solution to this?
I recognize the quandary, but I don't believe as though it's beyond this court's authority in this petition for review to consider itself whether or not the case is moot. Having the Court of Appeals order before you that doesn't supply a sufficient basis to explain how they found it to be moot, I don't believe as though there's anything preventing this court from examining the mootness question itself, and if it finds the case moot, to affirm the Court of Appeals. Whether they did so for the right reason or not, affirm the Court of Appeals, finding the case moot, and the case is done.
I wonder if we can, appellate jurisdiction is all about correcting the decisions of the lower courts. And how can we correct something we can't figure out what the foundation of it is?
I think you could correct it to the extent that if you were to issue an order analyzing the mootness question, issue an opinion analyzing the mootness question, it would resolve any inadequacy in the Court of Appeals order, because your ruling presumably would outline why you found the case moot. And that would resolve any ambiguity or confusion or insufficiency in the Court of Appeals order. The Court of Appeals order is going to have no bearing on anybody else's case. It's not an opinion, it's not a ruling. It's not precedential for other cases in that sense. So,
in doing that, how far would we wade then into the merits? If we got beyond just the fact that he's no longer in custody for sake of argument, that's what's shown, would we get into the hearsay and say, no, there's the hearsay objection, say, no, and just speculatively say, no, he signed a waiver, that didn't violate, whatever came in was fine? Or would we get then to your point that there's no consequence because he's completed his sentence? Would we then get into, well, is there a potential consequence? How far would we go? It seems to me that in answering that, that it's moot, we're kind of addressing the merits anyway.
if you were to answer that it's moot, I don't believe as though you're analyzing the merits question necessarily. You're just analyzing whether or not somebody who's out of custody has standing or has an appropriate place to argue the case before you. I believe that as though a ruling finding this case moot would stand silent on the merits of the underlying question. I don't know that you need to get to the merits of the hearsay issue. If this court is inclined to do so, I believe what Mr. Hodgkinson has requested is to have the case remanded, have this court find the case not to be moot, and have the case remanded for the Court of Appeals to decide the hearsay issue on the underlying briefs on the merits. The parties before you have not briefed to this court the hearsay issue, although we have briefed it on the merits at the court below. We'd be in a position to argue the hearsay issue there. But to the extent the mootness question rests essentially solely on whether or not he's in custody.
Or whether a probation revocation is a real consequence that defeats mootness.
Correct. That's true.
Would that be something we would analyze, or would that be something that the Court of Appeals, in determining whether it's moot or not, I would think that would be one of the questions if we get beyond the custody.
I agree with you. I agree with you. If you get beyond the custody and if you essentially start tiptoeing into the merits, then that is when you're talking about the revocation issue and how the interplay of the revocation issue with the mootness question, then that is something the court would move into. It isn't as though the hearsay being used against a defendant at a revocation hearing is a brand new issue. There's a body of case law that speaks to the hearsay issue. I realize we're not here on a petition on the hearsay issue itself, but the state's plenty prepared to argue the hearsay issue if the time comes, because there's a body of case law that speaks to that issue that we have briefed.
Mr. Gonteski, is your answer to the series of questions that came from my colleague to my left, Justice Biles, just basically we decide legal issues all the time, and we can decide a legal issue independent of whatever rationale the Court of Appeals had for its decision?
Well, when I look back to Hilton and Rayburn, it does appear as though the mootness question would be examined by this court with some sort of abuse of discretion rather than de novo, rather than as a new question of law. Those cases seem to speak to whether or not the Court of Appeals found a case to be moot and analyze whether or not the Court of Appeals made a legal error or a factual error in making such a finding. And so it does appear as though there would be something more than a de novo review or standard of review. But in the event that this court seeks to analyze that question and is stuck in the quandary of not having enough information from the Court of Appeals in the one sentence order, then I don't believe as though there would be anything preventing this court from deciding the mootness issue on a clean slate.
If we were to decide that this was moot, tell me how we get there in your view.
In my view, you would get to that point by recognizing that Mr. Yazel is no longer in custody, that remanding it for such a determination
Let me stop you right there. We would have to agree with you that what information you put forth is sufficient to have met. Is it your burden or is it the defendant's burden to show that he has standing?
I would argue it's his burden to show he has standing. He has that burden when he files his docketing statement, and it's essentially an ongoing one, that he is showing that he's burdened by the actions that were taken below. And he no longer is when he has been shown to be out of custody. Although he disputes the state's use of the Casper information and informing the Court of Appeals about the phone call to Cheryl Hensley, he doesn't dispute the underlying information. I think we would be here on a different posture if Mr. Hodgkinson was actually arguing the veracity of the information below. But he spent the previous 12 minutes before me moving all the way around the custody issue, but not directly answering. And that's because his client, he does not have any information indicating his client is in custody. And if he had as much, then perhaps we would be in a posture that remanding for some sort of adversarial hearing where the proof from both sides could be examined. Perhaps that's what would be appropriate but from a judicial economy standpoint. When we talk about a case that's been pending on petition for over a year, the underlying criminal case being years old and a 14-month sentence, we could do more. We could remand this back and have some sort of adversarial hearing, but to what end?
And on the issue of mootness, it's your position that it is opposing counsel's obligation or burden to prove that it is not moot, and he has not done so. And in the alternative, if it's your burden, you have done so.
Correct.
Based on this information.
Correct.
All right, thank you. Any further questions? Thank you, counsel.
Thank you.
Your Honor, I think my only point in response to that last argument and the line of questions that you have is, my general understanding is if a party files a motion to dismiss, some sort of dispositive motion, that it's their burden. The Kansas statutes say my client have a right to appeal every adverse decision of the district court, and I shouldn't have to do anything else to get my client's day in court. That if they feel and have evidence that there's some reason that my case should be dismissed, Like in Rayburn, like my client said, absconder, or in this case, if they can prove that the case is moot, then that should be their burden. I can't that would be a fundamental shift if suddenly, because we file a lot of appeals, and if in every appeal from this point going forward, I have to show the case isn't moot, in every appeal, that's the burden of every appellant, to affirmatively show at all times that the case isn't moot to get their day in court, that's a big shift. Thank you, Your Honor.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.